What is a divorce in Colorado and how is it legally defined? Now, what's actually interesting is that in Colorado, in the law, it's called marital dissolution, not divorce. But it is divorce. And so what a divorce is, first of all, what are the prerequisites? One has to be married. And in many states, that's actually not a thing that we have to think about a lot. But in Colorado, we do, because we actually represent several people every week, every month, who have to face that question first. Are we married? Because Colorado has common law marriage in addition to formal marriage. So formal marriage is easy. You got a marriage license, you had a ceremony by an officiant who is authorized by the state to conduct the ceremony, and they signed your license. You are married. Or you did that in some other state. Colorado recognizes marriages done in any of the other 50 states and pretty much any country in the world. But then there's common law marriage, and that is an entire another animal where you may think that you're married. And the law of common law marriage has changed and has been flexible. So it sometimes requires a lawyer to help you and then a court to decide whether, in fact, you were, in fact, married. But so marriage, once it's decided that you have one, is a contract. And it is a contract to share your life. And we don't need to go into all the details of all the things that are said in your vows. But it is a contract that then can only be broken by the state. There is no such thing as common law divorce. So a divorce is something that must be ruled on by the state. And then that dissolves, that's why it's called marital dissolution. It dissolves the marriage and puts the parties back in a place where they are no longer married, but distributes the assets and the fruits of the divorce, the debts of the divorce, in between the parties in what is deemed an equitable way. It also deals with the allocation of parental responsibilities. If there are children of the marriage, it deals with how the different parties are going to be allocated the responsibilities of supporting the children, raising the children, making decisions about the children, and of course having parenting time with the children. And that's those are all the things that are handled in a divorce in Colorado. In Colorado, there are no basic grounds for divorce. Colorado disposed of the cause portion of divorce. Most states historically had cause for divorce. And in fact, a long time ago, one had to show cause for divorce. One couldn't get a divorce just because they don't want to be married any longer. There was always there was frequently in many states a catch-all provision called irretrievably broken, which meant that the parties both agreed that the marriage was broken and could not be repaired. Colorado is what is known now as a no-fault divorce. And what's interesting about that is that a lot of people do still come to us at New Leaf Family and ask about what the effect will be of their ability to prove the other party's infidelity, the other party's cruelty, the other party's misbehavior in the marriage in one way or another. And we have to explain to them that Colorado is actually a no-fault state, that those things don't have much effect, except the one thing that is still very important is if one party has wasted the assets of the marriage, or if one party was abusive, particularly to the children, because that might affect the allocation of parental responsibilities. If they waste the assets of the marriage, then that could affect the distribution of the assets and debts. And of course, if they were abusive to the children, that could affect their parental rights regarding those children. One of the questions that clients ask when they first call us very, very frequently is, how long does this going to take? How long does divorce take in Colorado? And the answer is, it depends. That's the lawyer's answer, right? The average divorce, if there's nothing being contested, Colorado has a minimum of 91 days. from the time you file and serve to the time that the divorce can be granted. When there is a contest, when people are arguing and fighting over stuff, the average amount of time is between 7 to 10, 11 months. And it depends on county, it depends on time of year, it depends on what is being fought over and how hard folks are fighting. One of the unfortunate truths that I often tell people is that divorce can often take as long as the person who wants it to take the longest, right? Because there are lots of things you can do during the process of divorce that take time. If there are children, you can have a child and family investigator do an investigation or involve other professionals to do assessments of the parental relationship with the children. You can have forensic evaluators of the assets. You can have discovery, formal discovery, informal discovery. There are so many different things that one can do that do take time and that are legitimate in the process for certain divorces. These divorces, where all of these processes are maximized, can often take a year and a half. So it's quite a broad range of times that a divorce can take. But it, again, is dependent on the parties and depending on the questions that need to be answered. One of the questions that we get are folks that come to us after a very short marriage, where they, for better or worse, realize very quickly that this was not a good move for them, that the marriage was not a good decision. And the question often is this really a divorce? And the answer is, well, it depends. There are grounds where you can have a divorce, or a marriage rather, reversed. It's called annulled, to basically put the parties back where they were had they never been married, which is quite different from a divorce, because in an annulment, everybody's put back where they were. There's no division of assets and debts. Everybody's put back where they were. There's no minimum amount of time one must be married in order to be divorced. You could be married for a day, and it could be annulled, or it can be a divorce. What's the difference? The difference between an annulment and a divorce is whether the divorce was entered into without an intent to really enter into the marriage. So, for instance, one of the parties was already married. That's usually, in that case, actually, there's not even an annulment. The marriage is declared null and void. It never happened. One of the parties was fooled. So one of the parties tricked the other party with some fact that was material to a marriage. The most common one is whether that person could bear children. If someone lied about that, that could be cause for annulment. But there are other frauds that can also be perpetrated on the other party that could be grounds for annulment. But basically what you're looking for is, did the parties' minds meet? Did they intend to be married without any subterfuge, without any fraud between them? Then usually it's a divorce. If there was some subterfuge or fraud, then it is possible for it to be an annulment.